hope you listened to the radio show last night, but I want to go over something that actually is better done on TV because we're going to have the graphics and I have more time to spell it out without interruption, and that's this. In 1973, the Department of Justice under Richard Nixon prepared a very thorough memorandum. It was prepared by a special office that's at the Justice Department. It's called the Office of Legal Counsel to the President of the United States and the Attorney General of the United States. The best and the brightest constitutional lawyers work in that office. I'll give you an example. The Assistant Attorney General that headed that office many decades ago was William Rehnquist. As you know, he became a Supreme Court Justice, then the Chief Justice. Another Assistant Attorney General who headed that office was a man by the name of Antonin Scalia. You've heard of him. He became a Federal Circuit Judge in Washington, D.C., and then later an Associate Justice of the Supreme Court. So it's a very, very important office. Democrat, Republican Party, whoever controls justice doesn't matter. That's where a lot of the thinking goes on. And in that office in 1973, they were asked to produce a memorandum to determine for the Attorney General of the United States whether or not a sitting President of the United States can be indicted. Several years later, October 16, 2000, when the Clinton administration controlled the Justice Department, the office was asked to review the issue again, review the 1973 memorandum produced by the Nixon Justice Department, as well as three Supreme Court decisions that had taken place since the 1973 memorandum, even though those cases weren't directly on point. And they did that. And they issued that on October 16, 2000, as I said. Now, why does any of this matter to anything? Because you've been inundated. Many people have been brainwashed to believe that the President of the United States can be indicted for obstruction. As you're about to find out, you, among the few in the country, a sitting President of the United States will not be indicted. That's been the official position of the United States Justice Department for 44 years, almost half a century, Democrat, Republican. This President of the United States will not be indicted for criminal activity. Now, let it be said, and let's be very clear about this. Donald Trump did not obstruct justice. Donald Trump can't obstruct justice by firing Comey or by saying to Comey, I hope you can see past this investigation of Michael Flynn in so many words. The fact that Comey, after the fact, left his contemporaneous notes when he was testifying before the Senate Intelligence Committee and said he felt that he was ordered to do so. He didn't write that in his contemporaneous notes. The irony is his contemporaneous notes contradict his testimony. And of course, as you know, having watched before, if in fact he felt he was ordered to drop the investigation, and if he personally felt it was an obstruction, then he had statutory obligations to raise that issue, and he also had ethical obligations to raise the issue to, among others, the American people and members of Congress. But he had a statutory obligation to take it up to the Attorney General of the United States. He never did any of that stuff. So this is a ruse, and it's phony. So let's put that aside. I'm not here to debate obstruction of justice, even though I'm happy to do it. Here's the big issue. Mr. Mueller, the special counsel, must comply with the rules and regulations and policies of the United States Department of Justice. He's a special counsel. He's not the Attorney General. He's a special counsel. He's not above the law. Mr. Mueller must comply with this memo. And so the question is this. The question is one that is not being debated on cable TV or the Sunday shows on network TV or on radio. The issue is this. Why would Robert Mueller, now a special counsel, appointed by the Deputy Attorney General of the United States, why would Robert Mueller investigate Donald Trump at all? Now remember, this case has moved from a counterintelligence investigation to a criminal investigation. And the irony, second irony, is that now that it's a criminal investigation, the President of the United States, a sitting president, has immunity while he's President of the United States as a matter of constitutional interpretation and application. So if the President of the United States cannot be indicted for anything he's done while he's President, then what's the purpose of this scuttlebutt, this gossip dressed up as serious talk by Harvard law professors, by legal analysts on CNN, by every schmo who wanted to be a lawyer all over TV, saying, well, it is obstruction, it's not obstruction, well, maybe it's obstruction. What is the point of Mr. Mueller's criminal investigation if it involves Donald Trump? Obviously, he can investigate anybody he wants, anybody else. I guess he could even investigate the president, but for what purpose, to what ends? And I've argued repeatedly that Mr. Mueller, if this is what he's doing, seeks to put together a report that he'll issue publicly, which will be used as a pretext for a Democrat House of Representatives one day, if they win it, to impeach the President of the United States.